Is that because, if he had done so, he would have revealed either perhaps that Buckingham was solely responsible, or Buckingham was jointly responsible for bringing about the death of those princes? If he established that, then he would have made a bid for the throne of England in conjunction, in the abortive rising late in 83, in conjunction with the man who had put to death the two princes who stood in his, Henry VII's, way to the throne. And that he could not afford to do, for it would not have made his position upon the throne more secure. And so he avoided it. Why is it, you will ask yourself, that the Queen released the daughters, albeit the pressure upon her that Mr. Russell has referred to? But she not only released the daughters, she released the eldest daughter, who was a walking threat to Richard because of the promise of marriage made by Henry VII at the high altar at Rennes at Christmas 83. And not only did she release the daughters, but she sent for her son Dorset to put him too into the hands and at the mercy of the man whom she knew or believed had murdered her two children, Edward and Richard? Or was it that she knew and believed, or believed, that in fact it was Buckingham who had taken that step, or some person other than Richard? One other matter can I refer you to in relation to the pre-contract. There's nothing that small-minded lawyers enjoy more than anything else, is having a good old fight about a knotty problem, about a pre-contract or something of that kind. And my learned friend Mr. Russell and I, with the assistance of my lord, could have spent some hours going into the to's and fro's and the pros and cons of this question. I suggest to you, for your consideration, that Miss Sutton's view is a totally valid one, because it is supported by one really quite remarkable and outstanding fact. And that is that while complaint is made, in particular by Dr. Pollard, that no examination was made of Bishop Stillington in public about the existence of the pre-contract, the man who had the opportunity of making that examination frustrated the judges of the Exchequer and the Lords in Parliament who had resolved that such an examination of Stillington should take place. The man who prevented that was Henry VII. Why did he do that? If that had revealed, of course, that the two princes, Edward and Richard, were in fact bastards, it would have revealed also that his wife, Elizabeth, was illegitimate. And that would not have assisted the security of his seat upon the throne of England. And so there are layers and layers and layers which have got to be stripped from these facts before one can in fact get down to drawing fundamentally important conclusions about the facts which you have examined. Richard's silence can be attributed, certainly in the way that my learned friend Mr. Russell has attributed it, to the complicity of Richard, but that is not the only view. Richard would know perfectly well, such was the climate in England at that time, that for him to deny simply the murder of the princes would not have been acceptable to half the audience to whom he was speaking. So better to remain silent, as he did. It is not one of those facts that one can take hold of, as one can a book or a pen, and say, I have this, I see it, I know it, it proves itself. And there is in the examination that you've got to make here no one fact which can perform that task for you. For the basic premise of the prosecution case is this: the princes were a threat. They were in line for the throne, and therefore he had to kill them. There was another nephew who was equally a threat, if the princes were in fact a threat, who was nurtured and harboured by Richard as lovingly as if he was his own son, who so tragically died in the spring of 1484. Does that not, on its own, quite apart from those other elements that I have referred to, show you quite clearly that even upon the balance of probabilities, one cannot grasp firmly to say Richard is guilty? We can't prove that he is not, but that is not our task, as my Lord will tell you. For it must be, under our system, the case that the prosecution proves to your satisfaction that Richard is guilty. I thank you for your attention deeply.
Members of the jury, at the beginning of these proceedings, it seems a very long time ago now, I venture to say that what you, as the sole judges of the facts, are concerned with today is an endeavour to pass a historical judgment on King Richard III as to whether or not he murdered or caused to be murdered the princes in the Tower. It's a grave allegation, and that the fact that the king is dead does not make it less grave so far as his reputation is concerned. Calumnies against the dead, false accusations against the dead, even in a historical inquest, there should not be. On the other hand, if guilt can be established, and it is for the prosecution to establish it, as Mr. Dillon has pointed out to you, it is not for the defense to establish the king's innocence, but if the guilt is established, then it is right that at the bar of history that judgment should stand, for a duty is owed also to the dead princes, is it not? It was the great historian Lord Acton who said, history is a judgment seat. For the purposes of these proceedings, if when you consider your verdict, you can conclude and can say, we think it's more probable that King Richard did murder the princes than not, then a verdict of guilty would be right. If, on the other hand, the probabilities point the other way, or you think that the probabilities are equal, maybe one thing or the other, then your verdict should be one of not guilty. You will not forget that you're considering an allegation of murder. The more serious the allegation, the higher the degree of probability that is required. Now, members of the jury, I'm not going to review the whole of the evidence. You've heard it and you've been listening carefully to it. The time is late, and I don't know that I can take the matter very much further to assist you, so that I now invite you to retire to consider your verdict. There are two verdicts open to you, either a verdict of guilty or a verdict of not guilty. If you find yourselves unable to reach unanimity about your verdict, then I will be prepared to accept a majority verdict. And I hope that is clear to you. So will you now please be good enough to retire to consider your verdict. Thank you.